Extent of relief to be awarded in a judgment by default. The judgment by default shall not exceed the amount prayed for, nor be different in kind from that prayed for, nor award unliquidated damages. Why is there a limited relief in a judgment by default? It is settled that courts cannot grant a relief not prayed for in the pleadings or in excess of what is being sought by the party. They cannot also grant a relief without first ascertaining the evidence presented in support thereof. Due process considerations require that judgments must conform to and be supported by the pleadings and evidence presented in court. The Supreme Court expounded that due process considerations justify this requirement. It is improper to enter an order which exceeds the scope of relief sought by the pleadings, absent notice which affords the opposing party an opportunity to be heard with respect to the proposed relief. The fundamental purpose of the requirement that allegations of a complaint must provide the measure of recovery is to prevent surprise to the defendant. Notably, the rules is even more strict in safeguarding the right to due process of a defendant who was declared in default than of a defendant who participated in trial. For instance, amendment to conform to the evidence presented during trial is allowed the parties under the rules. But the same is not feasible when the defendant is declared in default because Section 3D, Rule 9 of the Rules of Court comes into play and limits the relief that may be granted by the courts to what has been prayed for in the complaint. To repeat, the court's grant of relief is limited only to what has been prayed for in the complaint or related thereto, supported by evidence, and covered by the party's cause of action. So there can be no additional grant under the general prayer, other reliefs and remedies just and equitable under the premises. So what is the reason for the limited relief in a judgment by default? The reason in limiting the extent of relief that may be granted is that it cannot be presumed that the defendant would not file an answer and allow himself to be declared in default had he known that the plaintiff will be accorded a relief greater than or different in kind from that sought in the complaint. No doubt, the reason behind Section 3D of Rule 9 of the Rules of Court is to safeguard defendants' right to due process against unforeseen and arbitrarily issued judgment. This, to the mind of the Supreme Court, is akin to the very essence of due process. It embodies the sporting idea of fair play and forbids the grant of relief on matters where the defendant was not given the opportunity to be heard thereon. While it may be said that by defaulting the defendant leaves himself at the mercy of the court, the rules nevertheless see to it that any judgment against him must be in accordance with the evidence required by law. The evidence of the plaintiff presented in the defendant's absence cannot be admitted if it is basically incompetent. Although the defendant would not be in a position to object, elementary justice requires that only legal evidence should be considered against him. If the same should prove insufficient to justify a judgment for the plaintiff, the complaint must be dismissed. And if a favorable judgment is justifiable, it cannot exceed in amount or be different in kind from what is prayed for in the complaint.